Okay, everyone, welcome to our town hall. Thank you all so much for joining us. I just want to introduce myself and my co-panelists. My name is Simone Meyer, and I'm the coordinating attorney for the Legal Health Housing Project. Also with me today is Howard Sherwin, a supervising attorney in Legal Health. And again, we thank you for joining us for this town hall on what tenants need to know now that the statewide eviction moratorium has ended. I just want everyone here to know that this is being recorded. So if you aren't able to write everything down as fast as you can, you will be able to watch it. We will also be able to send you links after the presentation so that you will you'll be hearing about different programs and protections for tenants, but that we will also be sending you a follow-up email if you were able to attend. So again, thank you for joining us. I wanted to speak a little bit about Legal Health. Legal Health is a division of the New York Legal Assistance Group and provides free legal services to patients at 636 hospital sites in New York City. We bring together legal and medical professionals in the healthcare setting. So many of you are here today, and we're so happy to have you. And we try to complement healthcare with legal care. I see a lot of people that I already know here that we work closely with. At the end of the presentation, we will give you more information on how exactly to refer cases to our clinics throughout the city. So there will be time for questions after the remarks, but you can also ask questions in the chat feature. We may answer them in the moment, but we might wait until after we speak briefly about what's going on. So we will be unable to answer questions about specific patients. So if you have those, please email us. If you don't have our email information, we can provide it. We will provide information again on how to refer cases to Legal Health. Once again, this presentation will be recorded and we will be sending out this information after we are done here. So let me start by saying on a little bit about the eviction moratorium that just ended. On January 15th, 2022, the statewide eviction moratorium in New York that has protected thousands of vulnerable tenants during the pandemic expired. The biggest immediate change caused by this is that tenants in New York State can no longer file what were known as hardship declarations in court. These hardship declarations, with a few exceptions, had previously automatically stopped any eviction case from moving forward if the tenant submitted a form stating they had been subject to financial or medical hardship due to the pandemic. Although these eviction cases, which are now in the tens of thousands in court, can now proceed in the eviction process, tenants should not despair or make rash decisions, such as moving out or abandoning their apartments. We hope that the most important takeaway from this town hall is the message for tenants not to panic and leave their apartments, especially in the middle of a surge in COVID cases and a very cold winter. Again, tenants should not abandon their apartments. The reason we say this is because many tenants that we speak to on the phone, your patients, feel pressure from landlords to leave without already having alternative housing. As we know, in New York City, there is an affordability crisis right now, and we don't want people leaving their apartments, going into shelters unnecessarily, or moving in with a family that can cause overcrowding and put them at risk. In fact, many tenants may have a right to stay and should certainly speak with a lawyer before leaving their apartment and abandoning it completely. They have time to prepare for a potential eviction, as well as apply for any rental assistance they are eligible for. There are many protections still available even with the expiration of this moratorium. So let's talk about those protections that are still in place. In New York State, tenants still must be served with the appropriate notices and court papers in order to even be brought to housing court.
Why am I upside down in this movie?
Because thank you for reading this part.
I think the speaker is muted now.
Simone, you're on mute.
Better?
Yes.
Great, thank you all. Teamwork. Okay, so I'm just gonna let everybody mute who is not muted. Thank you so much. Okay, again, in New York State, tenants must be served with appropriate notices and court papers in order to even be brought to housing court. Once a tenant is in housing court, eligible tenants will be given a lawyer their first day in court. And many of you know this as universal access or right to counsel, which is in New York City. And it is all zip codes now for people who are 200% of the poverty level or below. regardless of documentation or undocumented status. Once in housing court, again, they will get a lawyer their first court date. They can go to court in person or appear virtually or by phone. Their lawyer, once assigned, will review their case and will put forward their defenses and rights and appear in court with them. Tenants should be advised, do not abandon your apartment because of pressure from your landlord. Look out for court papers that could either be given to you personally or mailed to you. Ask for a lawyer in court. Do not agree to anything until you get a lawyer. Only a judge can order a tenant to leave their apartment. There are still COVID protections that are very important that can prevent evictions. At this point, the two most significant COVID-related protections are ERAP, which is the Emergency Rental Assistance Program. For the rest of the program, I'm going to refer to it as ERAP, and the Tenant Safe Harbor Act. I'm going to say Tenant Safe Harbor Act because TSHA is just kind of, it doesn't come off the tongue. So now I'm going to explain both these protections. The Emergency Rental Assistance Program, which is administered by the Office of Temporary Disability, OTDA, was launched in June of 2021 and allowed tenants to apply for up to 15 months of rental assistance as well as utility arrears. It also provided key protections in housing court. Namely, once an application was filed, the case was put on hold until there was a decision on the application, including an appeals process. Again, ERAP, once they had the application in place, they could go to court at any time, show that they had a pending ERAP application, and the case was put on hold. Now, ERAP, as many of my advocates and care coordinators here know, was briefly shut down in November of last year and opened up in January, just recently. And it's open again, and patients should be told to apply. We're going to put in the chat the link to apply on the OTDA website. And while more funds still need to be added, they can still go on and submit an application for the program. That way they have the protections, and those protections are in effect. Again, the protections when a tenant applies for ERAP are as follows. Like the hardship declaration previously filed, their case is on hold in housing court, giving them time to have the rental arrears come through. And then this is until a final decision is made on the application for rental arrears. Also, if a landlord receives this ERAP funding, the landlord cannot proceed with evicting that tenant for at least 1 year. So again, we're going to put this in the chat, the place where you can give patients information to apply for this rental assistance. They should not hesitate to apply. If they have questions about whether or not they're eligible, again, we're going to give you information on how to refer them to different enrolling programs. And I'm going to put that in the chat in a minute. But also, they are also welcome to speak with a legal health attorney to go over their rights. The second COVID-related protection is the Tenant Safe Harbor Act. Again, passed into law in 2020 at the height of the COVID pandemic. It states that no tenant can be evicted for rent that is owed from March 7th, 2020 through January 15th, 2022. So that is a very specific period of time. If that tenant experienced a financial hardship during that time, the Tenant Safe Harbor Act can stop them from being physically evicted. It does not stop a landlord from suing the tenant for the money owed and getting a money judgment, but it does stop a landlord from physically evicting a tenant from their apartment for monies proved owed during that COVID period. Unlike ERAP, the tenant cannot merely file something with the Tenant Safe Harbor Act and get the eviction proceedings put on pause. But the Tenant Safe Harbor Act is something that will be brought up when they receive an attorney in court. The end date for that, Marlon, was January 15th, 2022. That's the very significant date by which the moratorium ended. And for some reason, it is the date that they have ended the Tenant Safe Harbor Act protection period, even though we all know the pandemic is still going on. Possible in the near future, they'll make a decision to extend the Tenant Safe Harbor Act, but as of right now, the protected period is March 7th, 2020 through January 15th. So another thing in the chat, I'm just going to say, because we're just talking about ERAP, is it does not protect, so I think you said protect co-op and condo owners. ERAP does not apply for co-op or condo owners, but some co-op tenants who are behind in their maintenance can possibly do what's called a one-shot deal, or speak with a home-based individual to see if they're eligible for any other rental assistance. We're going to put all those links in the chat, and we'll send them out after this. Okay, so again, we want to reiterate the protections that are still in place for tenants. In New York City, a tenant must be brought to court in order to be removed from their home. Once in court, because of laws in place allowing for right to counsel in housing court, they will be provided an attorney from a legal services organization. Tenants can and should apply for the emergency rental assistance program and should provide proof of application to their landlord and to the court. They should also know any rent that accrued from March 2020 through January 15th, 2022 will not be the basis of an eviction, only a possible money judgment. Also, with all the cases that have been on hold, you can imagine the backlog of cases and now being put back on the calendar in housing court, it most likely will be a very slow, deliberate process, and tenants will get notice with enough time to adequately prepare to go to court and request an attorney and apply for that rental assistance. Patients who are worried about evictions can be referred to the legal health attorney at their hospital or clinic and can also call the Right to Counsel Center at 718-557-1379. We'll put that in the chat. And also they can look to newyorkcourts.gov, which has a lot of information about what's going on in housing court, about the Tenant Safe Harbor Act, and about ERAP protections. In order to refer a case to a legal health clinic site, you can look to our website to see if the clinic site where you are has its own clinic, and you can contact the social work department there to see about referring a patient. So we have a couple of questions, and at the end of our brief remarks, so Howard and I are opening it up to questions. The first question, and I'm going to start putting more links in the chat. So Howard, there is the first question about ERAP, and then there's another question. I'm going to answer the question about ERAP, the ins and outs. So ERAP, can you be approved more than once? It's a very good question that we have requested an answer from OTDA. We think that it depends on how much rent they received the first time, right? So if they applied for, they were up to 15 months rent for ERAP. But if they only applied for 6 months and then they fell behind again, it's possible they will be approved. But we don't know if OTDA is going to hold it against them that they had a ERAP application. It would be a good idea for them to go to an enroller, and I'm putting that in the chat right now, an enroller for ERAP to see, like BronxWorks is an enroller, etc., and ask them if they can apply again. Next question, Howard.
If I could just add to that, yes, I agree that I believe it will be limited. Am I on? Okay. I believe that it will be limited to the 15 months. But again, we're, as far as Simone said, a very important thing, takeaway we want from everyone is to go to ERAP if they have not, and if they believe they are eligible for ERAP. But if they go on the website, which is a very good website, has a lot of different links and a lot of questions and answers, the hypothetical questions and answers, they will see that it says there are no more funds if they haven't applied yet, but they shouldn't be deterred by that. Then it should still apply if they think they're applicable, because the hope is that come March, there will be funds that will be reallocated from the federal government that haven't been used yet, and hopefully we will get that. But regardless of whether those funds ever come to be, at this point, there should be a pause. If a person has an eviction case and files an ERAP application, there should be a pause on his or her eviction proceeding. Thanks. And the next question is.
The question, what if tenant's name is not on the lease because it was an illegal sublet?
Well, you want me to take that? I think that, well, what in terms of whether they are eligible for ERAP? I didn't see the question.
I think that's the question. Maybe we can get a little bit of clarity, but for ERAP.
Yeah, if you go on the ERAP website, on the OTDA website for ERAP, they have a lot of these different situations, including roommates and subletters, and I was certainly surprised at all the situations that were included that could be eligible for ERAP. But the bottom line is the money must go to the landlord and not to anyone else, not to the tenant who is subletting, or not to the roommate who might have paid and then paid for the other roommate, and the other roommate is applying for ERAP. It has to go to the owner, landlord. But in a situation like that, it probably could be, it is possible, yes. And there would, ERAP also allows people to self-attest as to their eligibility. So even if they maybe don't have like a written lease or the landlord or the person they were subletting from or would not give receipts, they could still that could still be looked into. So I would say yes, but basically to try when in doubt. And until you're rejected, then you should have that protection under ERAP in a court proceeding.
Yes, thank you, Howard. That if in doubt, go for it, because you'll be denied if in doubt. You could go for it. And there's 2 more questions about ERAP kind of logistics, so I'll answer those. But ERAP, how long does it take to get approved? Great question. Really depends on when you put it in, the type of housing you have, and your income levels. I'm not going to give a straightforward answer, not because we're not trying to be cagey, but we don't have a straightforward, there's not like a timetable for it. For instance, I have a client who applied in June, like the day it opened, 2021, still pending, even with a lawyer on the case pushing, because that person has Section 8. So it's been deep, kind of lower priority for people who are kind of on Section 8. So I don't have an exact timeline. If you feel like it's taking too long, call the help number. They answer the phone at OTDA, and they can tell you what's going on with the case and where it's at. Somebody else asked about, do you need to be a legal resident? No. So for ERAP, unlike one-shot deals, unlike public assistance, you do not have to have any particular status. You can be undocumented, which is pretty one of its kind in terms of rental assistance. You do not have to have any status to apply for ERAP. So please advise your patients about that and make sure that they don't have any worries about public charge, as well as public charge does not apply in this situation. People think if they take money, it's going to be used against them in the future in their immigration case. It will not be used against them.
And if I could also add, the money does not have to be paid back for ERAP, and yes, it does not count as taxes or income for any government programs.
Okay, we have another ERAP logistics question. I have several clients who applied before the cutoff and they are just going nowhere. The landlords have done everything they can as the tenant, as has the tenant. Okay. Again, I would say if they're having issues with ERAP, they can do 2 things. They can call the helpline and see what the problem is. Also, we're happy at one of those enrollers is also a good place to go to see what the problem is. They might have better insight. We're always happy to take a referral from them as well to see if there's something legally occurring that they're being blocked from this sort of assistance.
I would, Simone, if could add too for that. The question I would ask that person that you're having a problem with is, are they currently in an eviction proceeding? Do they have court papers? Because that's what Simone and my focus is generally on. Because if they have this ERAP application, I think the more important thing than getting an answer from ERAP is to make sure that the court and the opposing counsel for the landlord's attorney and the landlord knows that there's still an ERAP pending application, and therefore the eviction can go ahead. So, I think in terms of getting in touch with ERAP and finding, in some ways, if they do have an eviction proceeding, in some ways, not getting an answer from them is kind of helpful to stalling the case so you can put things in place.
Yes, there was a frustration in the chat, just understandably, that the amazing social worker in this case has been calling ERAP and OTDA, and it seems stalled. What can I do? As Howard's saying, the key protection here is what's important. And I know it's frustrating for tenants because they don't want to be a person who owes money and maybe their landlord's bugging them about it. But the key protection is there. That's what's important. The ERAP application is pending, therefore they cannot be evicted. It will get worked out. I'd say that it's a little bit messy right now there with trying to figure out even how to infuse funds back into the ERAP program. So sorry, we don't have a clear kind of class action response to that, but the protections are there. Howard, I'm going to circle back to the question that somebody asked about protections. We thought it was an ERAP question, but in fact, it's whether can a landlord evict an illegal sublet tenant? That was their question. Wait. So if we're saying,
which
that's okay.
question was that? Was that the NYCHA one?
No, it was earlier just to say, do these protections count to illegally subletting tenants?
I'm so good. How are you?
And the question is whether a landlord right now can evict an illegal sublet tenant. So we would say a person in that situation, if they've been there for more than 30 days, you do have to bring them, the landlord have to bring them to court to say, this is illegal, it was a sublet, I didn't know. Also, they have to take it up with the original tenant who has the actual relationship with them, the lease, that they breached the lease. So they can go to court. Yes, if the person is behind in rent and they applied for ERAP, it's possible that that case could be put on hold. If you're asking about if the Tenant Safe Harbor Act is in play here, it's not really relevant because it's about evicting someone based on their status in the apartment. So yes, landlords are free to go forward, and because there's no more hardship declarations,
Yes.
to go ahead and evict. But it's a long process and there's a lot of backlog. So yeah, I hope I answered that question.
Sounds good to me.
And in NYCHA, that's even more messy. Who's asking that question? So it's a little messy, but NYCHA would have to bring the proper proceedings against that person. What can be submitted to landlords as proof of application for ERAP? Great question. I think it's just a matter of when you apply for it, it comes up with a page with an application number, and you can just print that out and send it to them. Whether they do something with it, up to them, but it doesn't matter because if they do come to court, they know they're not supposed to proceed until this is done, so the court will put it on hold. But that's what I've been giving to landlords. Okay, I'm getting some direct messages. I'm not sure if people want to put them in the chat, but I will see. Our ERAP application is still valid after January 15th, 2022. Yes, so it's reopened. Yes. So we would like people to apply. It actually reopened before that Saturday, which was great because we have something thanks to legal aid for suing and making it reopen again. Yes, so that's the answer to that.
Yes, but again, if you already have an application, you don't have to file a new one.
Exactly. Thank you, Howard. The Right to Counsel Center, what do? Do they assist with the application or guidance or both? They help give what we're doing here, but on a one-on-one level, what we do in clinic as well, which is they tell you, okay, here's where you're at, here are your rights, here's what you need to look out for. Make sure that you look for court papers, you go to court or you call court, etc. They're very helpful, as is Housing Court Answers.
If I could jump in, just the right to counsel. One of the things, one of the big takeaways we also want everyone to have is that best to have an attorney if you're in court. You should absolutely have an attorney. The right to counsel, universal access, New York City is very fortunate to have that. And it's been greatly expanded, the right to counsel. So again, it's all zip codes now. Income, although they will look at income, but it's very, I think they're going to be very loose about that. And I think certainly if a person is facing a warrant of eviction, they're entitled to free counsel regardless of income. And status doesn't matter, but the important thing is how they really need to best have an attorney. And I think this is a statistic that about 84% of people who have attorneys in housing court avoid eviction. So, we make a difference.
Absolutely. There's a lot of housing court attorneys being hired by the city, so that's great. There's a question about the city advising tenants to apply for ERAP and one-shot deals. I haven't heard that. I don't think Howard has it either, but I think there was a period where ERAP was shut down, where then people moved over to doing one-shot deals. And in order to get a one-shot deal during the period where ERAP was open, you would have to prove that you applied and that, what's going on with that. So, if you were denied ERAP, then go do a one-shot deal. If you are pending ERAP, one-shot deal is going to say it's pending. HRA is going to say that we're not going to process this one-shot deal until your ERAP is taken care of. Now, if it's one-shot deal money for November to now, it's possible that they would process that. It's a little bit of a, we're in between transition period of time. I was on a call, we're all on the call with the new HRA commissioner, and that wasn't really made clear this week. Thank you to others who've answered each other's questions in the chat. It's always great. Elvita and Hannah, thank you. That's awesome. And I love working with you all because you all know the answers sometimes better than we do. How can we request a notice from ERAP with outcome of an application, especially one that was, according to them, never actually submitted? So ERAP has everything on that website I sent, showing if you have the application number and the date of birth, where the case is at. But if they're saying it was never submitted, then I would assume you do or do not have an application number. So it's something I would refer them, if you know of the clinic where they go to the hospital, I would refer them to our office or to one of the enrollers for ERAP to see what the problem is. On the website, it says there are very limited funds. I'm sorry, Howard, go ahead.
No, go ahead, continue.
So on the website, Samara, it says there's very limited funds. That was written right before the end of ERAP. It's still on there. There are basically no funds in it anymore, so that's an understatement, but they're trying to infuse those funds back in. The governor is trying to get money from federal money, so they are trying. It's just, it might not be until March we're hearing, but I'm not going to hold anybody to that timeline. Good question, Howard. I'm going to read it if you want to take it on, because it's about summary proceedings and eviction notices and ERAP. If a tenant has an eviction notice, but the tenant is not eligible for ERAP because surpasses income limits, will the case be placed on hold? So they're not.
Okay, thank you. Has an eviction notice, but the tenant is not eligible for ERAP. Well, first of all, again, that person, if the application went through and is pending, the person should notify the landlord or the landlord's attorney and the court that they have an ERAP application pending and that it hasn't been decided yet. Because again, if they say no, because maybe they computed their income wrong, or maybe they didn't take certain deductions, or then you could, and so the person could maybe appeal. So until even through it goes through the appeals process too, in terms of a final disposition by OTDA for ERAP. So I would say the case would be put on hold as long as the court has noticed that there's still a pending application for ERAP. But once it is definitively, there's a statement from ERAP, and they will send a letter saying that you've been denied, and or the appeal has been denied, then the cases could proceed without any of the protections of ERAP. Does that answer the question?
Yes, that was great. I'm going to see if there's any other questions. I asked a few people to clarify a direct message just because the question was a little confusing. So I just want to see if anybody has any more questions. We'll give it another minute. And yeah, I could. Go ahead.
I say, is there a limit in how long you should submit supporting documents on behalf of a landlord? I mean, that gets into, I think sometimes you have a non-cooperative landlord who's not submitting the documents that they're supposed to with ERAP. The ERAP is, I think, supposed to hold it open for at least 4 months, I believe, to and go after that landlord to try and get it, to get that information. And then at a certain point, if the landlord refuses to cooperate or says, I don't want to deal with this ERAP, then the tenant should get a letter from ERAP stating that, And that could be used as a defense in an eviction proceeding, and the landlord should be prevented from moving ahead with the eviction or evicting for any monies that would be covered in an ERAP application.
Yes,
Okay.
great.
And
Someone has
the
a
other thing I
patient.
just want to
Go ahead.
clarify too with the ERAP, sorry, is that it just covers, Simone had pointed out that it protects someone if the landlord accepts ERAP for a year, that they cannot be evicted. And just to clarify that they can be evicted if they don't pay their rent again after that. They could bring a new non-payment proceeding, but they can't be evicted for something called a holdover proceeding, where the landlord's claiming that their lease is run out or they don't want to renew their lease. That they have to give them at least a year.
Yes, yes, and thank you for that. I just answered the question in the chat about if something's pending, ERAP is pending, should they reapply? They should not reapply. They should just check on the pending application. Someone asked that they don't have someone who needs rental assistance, but utilities assistance, but they're undocumented. Are there any resources? A very good point that if you do have utility arrears, you also have to have rental arrears. So with respect to that, I would look at what's going on with the undocumented tenant. If they are alone, I would say Home Base and Project Parachute, again, I'll put that in the chat, is a great place that has specific funding for undocumented tenants who are facing issues such as that. But I would also look at the home and see if there's any other children in the home, right? Are there citizen children in the home? Are they on a public assistance case? Then they can apply for essentially a one-shot deal for the utilities based on the fact that children are on the public assistance case, or sign up for HEAP, which is a program that helps individuals pay off their high utilities over time. When is ERAP going to be lifted? I think you mean when maybe the funds will be available or when it will end. I don't have an answer to either one of those questions, but it's ERAP is in place. And again, the most important part of this is it's back in place, which is great because it's the best protection against eviction now that the moratorium is over. It's open, tenants can apply. It's frustrating that we don't have answers to when the money will be there and also when the applications will be finished. But that is, I hope, answering the question. Yes, I will put in, I'm going to put again, Homebase's website, and Project Parachute is the project for undocumented tenants that helps them through Homebase. Other questions? Great. If there's no other questions, we are just going to sum up and say thank you for coming, and please advise again to your tenants, to the patients that they can speak with a lawyer. They have that right, either our office or a right to counsel. They should not abandon their apartment. They should look for papers that come in the mail. They should attend those hearings over the phone or in person if they need, and they should apply for ERAP and show the court that they've applied. If it's a different type of case that has nothing to do with money, they will be given counsel if they're eligible, and they can always speak with our office or right to counsel. Someone asked, how do you reach us? Again, if you go we're going to send out, please sign up for the newsletter that Allison sent, and that way you'll be able to get our newsletter. Allison put it in, and we could put it in again, but you can email her to subscribe to our monthly newsletter. For specific patients who need legal assistance, please see if your clinic site or hospital site is one that is covered by Legal Health, and you will go to the social work office and you will be given the attorney who works at that site. Anything else, Howard?
No, I think nothing else. Just yeah, if anyone has any other questions, but again, try to encourage your client to to go to a lawyer, and also that this is going to be, so people might see, like I think on CBS News I saw the other day, they used how there's going to be an avalanche of evictions. So it's clearly gonna be a challenge for everyone involved in this process, but I think, they have so many and there is gonna be hopefully an order to it. And the older cases are gonna be dealt with first, and then, and there is going to be sufficient notice for everyone. They're not going to get notice show up in court 2 days from now, and there's going to be, and again, that people should be encouraged. They don't have to show up in the courthouse, that it is still that remote appearances or even by phone for people who don't have the technology is encouraged. They don't want people in the courthouse at this point still, but if they must, they still are allowed to go into the courthouse are open per se.
Yes. Thank you all, and thank you for all your thanks, and thank you for all you do in these extremely difficult
Yes,
times.
thank
You're the
you.
ones on the front line, and we are so lucky to be partnered with you all. And thanks for coming. And we will send this information out with the recording. And thank you, Allison, for everything you've done to organize. Randy Retkin, our director, Julie Brandfield, our
Thanks.
associate director, and thanks, Howard.
Thank you, Simone, and thanks to everyone.